Good morning, everyone. Thank you for coming. You don't need to rush back. You can keep grabbing food. But on behalf of the NYU Journal of International Law and Politics, thank you for joining us for our annual spring symposium, States of Violence, Law, Power, and Accountability. I'm Emma Nissenson, editor-in-chief of the journal. We're grateful to have such a wide mix of students, faculty, practitioners, and members of the public with us today. And we're especially thankful to our panelists for being here. Today's symposium would not be possible without the generous support of the Intellectual Life Fund provided by the Law School's Office of Student Affairs and Katie Shirley, who helps with the purchasing, accommodations, and logistics for this event. We are also grateful for the support of our faculty advisor, Professor Jose Alvarez, who has actively supported and assisted in the development of this symposium. Importantly, I would like to thank Richmond Brodigan, the senior symposium editor, for dedicating so much time and energy to organizing this symposium, including getting all of the speakers here from various parts of the world. I am grateful for the care and thoughtfulness you put into this to bring this event together today. Finally, I would like to thank our esteemed group of panelists for joining us today for a discussion of this important and timely topic. We are meeting at a moment in which some of the basic assumptions that have long underwritten international law feel increasingly unstable. Commitments to human rights, to sovereign equality, and to legal accountability have not disappeared, but their capacity to constrain state behavior, limit violence, and provide redress now feels far less certain than it did even a decade ago. We see this instability in open dismissals of international law, including from senior state leadership. We see it in unilateral military actions framed as necessity rather than exception, and we see it in the growing willingness of major global actors to treat international legal obligations not as binding constraints, but as optional commitments. When we speak about accountability for violations of human rights or breaches of sovereign rights, we are not invoking abstractions. These commitments have long been understood as foundational to collective security, to shared values, and to the principle that law, rather than raw power, should ground the dignity of individuals and the sovereign equality of states. And yet, those assumptions now sit on increasingly fragile ground. In a moment of fragmentation, what matters is how we recalibrate international law when its mechanisms strain, accountability fragments, and violence is administered not only through force, but through the exploitation of legal structures themselves. This symposium begins from the premise that critique, creativity, and renewed attention to accountability and international duties is increasingly demanded and necessary. Across today's discussions, we ask not only where international law falls short, but how its doctrines might be re-examined in light of the forms of violence they are now asked to govern. Today, we begin with a conversation that takes up this challenge directly. Our first session, Neutrality, Restraint, and the Politics of International Law, focuses on a body of law that is often seen as being too passive, but that may be uniquely relevant to contemporary forms of conflict, neutrality. In an era in which military involvement increasingly takes indirect forms through intelligence, sharing, logistics, financing, cyber operations, and private actors, existing legal frameworks often struggle to allocate responsibility. This discussion asks whether neutrality law, properly understood and reimagined, offers an effects-based way of thinking about third state responsibility that offers a potential solution to assigning accountability to third states intervening directly or indirectly in other countries and affecting the lives of their citizens. We are very pleased to be joined by Cherry Tang and Professor Jose E. Alvarez for this discussion. We're especially grateful to Cherry for joining us remotely from Australia and at what is a very late hour there. Professor Jose Alvarez is the Hamilton Fish Professor of International Law at NYU School of Law and the Faculty Director of NYU's U.S. Asia Law Institute. He is a former president of the American Society of International Law and a former co-editor-in-chief of the American Journal of International Law. Professor Jose Alvarez has written extensively on international organizations, international investment law, and global governance, and is the author or editor of numerous books and articles in the field. In 2024, he was awarded the Manly O. Hudson Medal, the American Society of International Law's highest honor. Cherry Tang is an academic at the University of Technology, Sydney, in Australia, where she lectures on international organizations. Her scholarship and academic interests focus on public international law, doctrinal and critical, and she is the author of Neutrality's Unfinished Business, forthcoming in the NYU Journal of International Law and Politics. Each of today's sessions will include approximately 10 to 15 minutes for audience questions and discussion at the end of the panel. So please join me in welcoming our speakers for this first discussion today.
So, Professor Tang, I hope you can hear me. Is that okay on your end?
Yes, I can hear you. Hi, hello.
I'm very relieved because I can certainly not present your article. At the outset, I think you should know that the audience has not seen your article. I was lucky enough to be able to see the draft that's forthcoming, and I know you're still apparently tinkering with the edges of it, so I hope that this is helpful in some way. But for the sake of making sure the audience is on a page, the same page, perhaps you can spend a few minutes now and perhaps not just describe the thesis, but how you came to write it. Because keep in mind, we have in this room some folks who are thinking of publishing themselves, and the academic enterprise is part of the game. So I turn over to you to present the paper as if you were in an elevator that stuck, but for only 10 minutes.
Thanks again, Jose, for very kindly moderating this. And of course, please feel free to interrupt me and ask questions as I talk about the thesis, as well as, of course, the background to writing the project. So the project is about reviving the law of neutrality. For those in the audience who might not be familiar with the law of neutrality essentially requires that neutral states, third states that are not participating in a war and an international armed conflict, requires that they be neutral with respect to and essentially do not involve in a war fought between other states. So, for example, a neutral state may not supply what is called warships, ammunition, or war material to a belligerent state. And this obligation, amongst others, have been codified in the two Hague Conventions of 1907, which, as most writers agree, reflect customary international law at that time. And the question I sought to ask in the project is, what does being neutral mean, not just in a historical sense, but in the contemporary world? And does this law do good things? And my answer to this question is yes. Neutrality law does do a lot of good things, and specifically, in my view, it offers the potential for a less interventionist world, if you will, which we are seeing now. And I fear that neutrality law has not been given sufficient credit, particularly in recent writings, some of which have sort of questioned its relevance and some of which claimed that it's a dangerous body of law. And in making this claim, which I'll explain more in a second, I was motivated, as most academics do, by both a doctrinal problem and a political problem. Starting with the political problem, a phenomenon I see in contemporary international armed conflicts is the amount of involvement there is from countries not officially fighting in the war. The ongoing war in Gaza, for example, is plagued by weapons supplied by third countries to Israel. In the 2 years since October 7, the US government, for example, has spent almost $22 billion on military aid to Israel. The UK, Australia, Canada, and a few European countries are also doing the same. And looking beyond Gaza, since Saudi Arabia's military intervention in Yemen's civil war in 2015, I believe, the US and the UK have together transferred several billion dollars worth of arms to Saudi Arabia. in the war in Ukraine, yet another example of an ongoing war, the largest donors of aid to Ukraine are similarly the superpowers, UK, EU, US, Germany, that we can see in the list of kind of top donors, with the US government, for example, has spent around more than few hundred billions of aid. And merits of the involvement of these non-participant states in those in providing military assistance or otherwise aside, this sort of proxy conduct slash countries funding war has dominated much of contemporary warfare. And I say that these countries are not officially a participant in the armed conflict because assistance, including, for example, providing weapons, providing funding for military purposes, these assistances unlikely rises to the level of the use of force within a meaning of Article 2.4 of the UN Charter, or otherwise for them to be qualified as a co-belligerent within the meaning of IHL, or co-participant, if you will. However, this actually remains a tricky question, which, although is not what my article is about, it suffices to note that providing weapons to a belligerent in war may sometimes constitute a use of force, although it is not yet clear what some of those conditions might be. Some writers have said that the supply of weapons may be causally linked to the fight, must be coercive, and so on. But what neutrality doesn't do, and that's important to know, what it doesn't override is the governing of the use of force under the jus et bellum. And that is, it does not tell us when a state might have crossed the line to become a participant in a conflict. It does, however, tell us that when a state is not a participant in the conflict, what can they do, and what can they not do? So this is the political problem that I was motivated by, where third states are operating in this sort of gray area where they're doing things that affect the trajectory and potentially exacerbating the humanitarian consequences of the war, yet seemingly unaccountable as the language of neutrality seems to be increasingly fallen out of use. Although as I could explain, it's still a language used in existing military manuals in a lot of states. And turning then briefly to the doctrinal problem that I flagged, there are two. The first is neutrality law has kind of received a somewhat bad rep in recent years, especially since the war in Ukraine, which is obviously clearly illegal, in that Russia has clearly violated the provision and use of force, aggression, and so on. Writers have questioned whether the law of neutrality has become optional or qualified, or whether because of that, neutrality has become irrelevant or obsolete or dangerous. And this was mainly because helping Ukraine is considered the right thing to do. What has bothered me, however, is what about in other conflicts? How do we determine what the right thing to do is? And the positions of the arguments of qualified and optional neutrality do not give us this answer, other than, for example, saying that helping the victim state is right. And I reject these positions. And my view, and my opinion, and in my opinion, the doctrinally correct view, is that states must prima facie be neutral. You don't assist states fighting in a war based on only the state's judgment of the moralities of the war. There are circumstances where states might be able to assist a so-called victim state. However, that must, in order to do that, the state must undergo a proper legal analysis as to whether there are such circumstances available to preclude the wrongfulness of violating neutrality law. And I say that Ukraine is an example of the availability of an excuse to violate neutrality law. And the second kind of doctrinal issue is that recent years have seen an increased use of cyber tools or intelligence in armed conflicts and things that are kind of more difficult to materialize in a physical sense. And I wanted to question how neutrality law, which was drafted, Hague Conventions was drafted in the 1900s, how do they regulate these activities? And I will conclude that they regulate these activities quite well.
Okay, so let's, we're running the end of the elevator, so let's turn to, just for clarification, you said at the outset that the Hague Conventions of 1907 reflected customary international law at that time. As I read your article, it is partly doctrinal. It is not just attacking the policy arguments directed at neutrality. It is saying that the Hague Conventions remain in force, they remain treaty law for all their parties, and that the customary law that it reflected continues to be customary law today, despite the fact that many states don't refer to it, certainly not with respect to either Israel or Ukraine, but instead say we are coming to the collective self-defense and leave it at that. So I want to make sure this is not just a paper about the policy arguments about why neutrality law should be used. It is very much a legal argument that says the states that are violating neutrality law, that is, as I understand your article, you're either a belligerent or you're neutral. You cannot be in between. So any aid to Ukraine, any aid to Israel, whether it's on October 8th or today, was illegal from the outset unless you are a belligerent and willing to be called a co-belligerent. So am I misunderstanding any part of that?
If I could just clarify with my answer with a few points. You've alluded to a lot of important things, including firstly, whether states have not used neutrality or referred to neutrality in recent years. That is whether state practice has kind of shown that neutrality has not really existed these days. Secondly, whether in the matter of Ukraine and in Israel, for example, whether it is my argument that states must satisfy themselves that they should become co-belligerent in order to assist either of those states. So just responding to the first issue first, the main problem with state practice using neutrality law is that most writers agree that state practice is at most inconclusive. It is still referred to in the military manuals in the United States, in the UK, in Australia, and many superpowers. However, it is not the case that neutrality has not actually been referred to since 1945, for example. In the Iran-Iraq War, it was asserted by the UK and the US that, by the UK especially, that they're still adopting a position of neutrality, even though some of the assistances they gave at that time might objectively be breaching neutrality. In the Korea War, for example, China, as an example, was asserting neutrality at that time, even though they were assisting North Korea at various points during the war. So it was actually in the discussion by states at various times during international armed conflicts, even after the establishment of the UN and the coming into force of the UN Charter. As to the recent two wars, in response to the second query, it is definitely not my position that states must be a co-belligerent to a war in order to assist any of those states. And this comes to the circumstances precluding wrongfulness point that I lightly alluded to, which is, my point is that neutrality prima facie applies to all third states when they're not participating in the armed conflict. So states other than Ukraine and Russia in the war in Ukraine, with respect to the war in Ukraine, must prima facie be neutral. However, they could, where there are circumstances precluding wrongfulness, and that's and collective countermeasures is that circumstance precluding wrongfulness that I say would apply to excuse a violation of neutrality if a state such as the UK is satisfied that Russia, for example, has violated a use cogence obligation, such as aggression, they would be able to, on this proper legal analysis, still remain a neutral state, however, violate the obligations required of as a neutral state, and as a result, assist Ukraine without being a co-belligerent in that armed conflict. So this is the kind of the critical part of the thesis, which is that neutrality law does not affect how you become a belligerent. You are able to assert collective self-defense, if you will, in order to be a co-belligerent. However, this is actually not the case with respect to both assistance rendered to Israel as well as assistance rendered to Ukraine. I think other than one state, Albania, with respect to the case in Ukraine, all the other states who have assisted Ukraine have asserted that they were merely condemning Russia's aggression as well as assisting Ukraine to realize its own self-defense. The phrase collective self-defense wasn't actually asserted by any of the states other than, I think, Albania. And I think there was an article nicely written about summarizing all the state practice with respect to using neutrality law about Ukraine. And in the case of Israel as well and Palestine, it wasn't states who were assisting Israel was careful not to cross the line and cross the red line to be a co-belligerent in the conflict. And although it's in my opinion unclear, it's not really properly justified as a matter of violating neutrality law, whether their assistance it's not really properly justified. However, this goes to show that you don't really need to be a co-belligerent in order to assist a state if you can satisfy yourself that there are circumstances precluding wrongfulness.
So I guess I'm still a bit confused about what to you is the difference between the proper citation of I'm asserting countermeasures in those instances versus declaring I'm coming to the aid of either Kuwait, Israel, Venezuela, or Ukraine. But just so to be clear, through countermeasures, as I've always understand it, you are not supposed to turn to anything that would be a military assistance. And so I want to be sure I understand what you are permitted to do under countermeasures that would not provide a military advantage, which is your broad assertion of what would violate neutrality law. So what is it that the U.S. and others can lawfully do, in your view, under countermeasures? And I think, unless I misread your piece, a good number of the things you describe as violating neutrality law include providing satellite coverage through your private companies, providing technology, providing even short of military arms, anything that confers a military advantage to one side violates neutrality law. So what is it you can do through countermeasures? And remember, and I take it I take it seriously that you think states can take countermeasures in response to what you describe as jus cogens. Now, the latest list of jus cogens includes violating self-determination rights, which would be presumably at stake in things like Ukraine. So please clarify for me what you can do under countermeasures that doesn't violate what you think is binding customary as well as treaty law, neutrality law.
Collective countermeasures is for people who might not know, is a circumstances precluding wrongfulness under the Articles of State Responsibility. And it acts as a second layer of ascertaining obligation. First, you ascertain whether there's a violation of the law, and secondly, you go to assert whether there is one of any circumstances precluding wrongfulness, and collective countermeasures is one of them. As I understand it, the paragraph under collective countermeasures in the Articles of State Responsibility provides that it does not excuse the use of force, and it's not an exception to the use of force, and therefore collective countermeasures, as what Jose has mentioned, it does not authorize the use of force. What is tricky, however, is that the act of providing weapons, military assistance, intelligence, funding, and so on, they do not necessarily rise to the level of the use of force, and they do not necessarily involve the use of force. And although this is not the main, as I said, the main discussion that I have in the article, but I refer to academic discussions that have discussed this very tricky question, including a recent writing a piece that discussed that in order for a supply of weapons to constitute the use of force, it must satisfy a few conditions, including it must be causally linked to a fight, it must be intentionally coercive in nature to the opposing side of the conflict, and so on. And this doesn't, that doesn't actually become incompatible with the assertion of collective self-defense, because if, for example, these assistance based on doctrinal analysis of what collective countermeasures or what the use of force threshold is, if they do not rise to the level of the use of force, neutrality law applies. It says that you can't do that, but then you may do that if you're responding to a jus cogens violation. I take no problem with the expanding list of jus cogens violations. What I take credit, what I see the credit of neutrality law and the subsequent use of circumstances precluding wrongfulness is the availability of a legal justification and the availability of asserting that this is a proportionate response to the fight. This is, the state aggrieved, a belligerent state aggrieved, for example, might sue the neutral state violating neutral duties. And this is what I see the good thing about neutrality law and so on is. And then if, to continue on the analysis I was giving, if there's assistance, including supply weapons and so on, funding, I don't think rises to the level of the use of force within the Nicaragua judgment, meaning if they constitute a use of force, then states could assert collective self-defense if they would like to. There's nothing in neutrality law that prevents the the assertion of collective self-defense, if it does, even if it does, the UN Charter definitely takes precedence as what the nuclear weapons advisory opinion has alluded to, that neutrality law does give way to the UN Charter in circumstances where they conflict. And this is the issue when they might have conflict, and how this interaction between the USAP element and neutrality law, how they interact, it remains a tricky question. But
So I guess I want to pursue what you just said about it gives way to the UN Charter. Again, as I read your piece, it seems that the collective self-defense of small states that could be very much at risk in the world we're approaching, and here I'm talking about every country that is subject to the new Dunroe Doctrine of the United States, every country that China might deem worthy of invasion, whether it's small islands in the South China Sea or Taiwan, and everything in Europe that Putin thinks is part of the Soviet Empire, all of them are up for grabs until the Security Council magically would declare aggression and open the door to collective self-defense under Article 51. Is that the case?
no, I don't think that's the case, because the idea that states' use of collective self-defense is at risk is not consistent with the idea that neutrality gives way to the UN Charter, and that neutrality law essentially does not govern when states might be able to use force. What neutrality law governs is sort of assistances and the provision of assistance that falls short of the use of force, whether or not and when states can use force in collective self-defense amongst whether it's small or middle powers, if they want to assert collective self-defense. This leads to analysis of Article 51 of the UN Charter, and the fact that neutrality law is there governing a subset of activities falling short of the use of force does not affect states using force in support of each other. And that would lead to an illegal analysis under Article 51, and whether it justifies the exception
Which
to
is,
the prohibition.
as I understand it, what you mean by the until phrase in Article 51, which obviously many states think this is not a suicide pact. That is, if the Security Council doesn't do anything, we still have inherent both self-defense and inherent collective self-defense, which was not destroyed by the Charter, and that's how people talk about it, inherent. And so I agree with you that there may be differences along the spectrum of what the until phrase does, but the bottom line is pretty much no state says, okay, I've alerted the Security Council like I've done. The Security Council has done nothing, as I've described in all the possible cases that involve China, Russia, and the US. I'm still waiting for the Security Council to do something, and in the end, we just get killed?
Yeah, I don't, well, in response to the first statement you just made, that the states are not signing up to a suicide pact and they're allowed to use collective and self-defense whenever they want to, I completely agree with that. That's correct. And the correctness of that is not undermined by the law of neutrality, because the law of neutrality is not about when states can use force against other states. It's about when states can assist other states falling short of the use of force. And if China invade Taiwan tomorrow and America wants to assist Taiwan, the US would prima facie be a neutral state under my analysis under the law of neutrality. However, if it considers the the analysis goes two ways. If it considers that China's invasion of Taiwan has breached numerous use cogence obligations, it may assist Taiwan by providing military supplies or anything falling short of the use of force against China in breach of the law of neutrality, but with the circumstances precluding wrongfulness under collective countermeasures. And then secondly, if the US decides to use force against China when there's in assistance of Taiwan, then the collective self-defense analysis will come in, and the US will be able to assert that. And that analysis, I say, come in because using force against China would essentially make US a party to the armed conflict, and given the threat that the relatively low threshold of being a co-participant in armed conflict under IHL, and in that case, neutrality law ceases to apply. It will not affect the US's right to use its collective self-defense, to assert collective self-defense in aid of Taiwan. And that's where the critical point comes in, is when neutrality law gives way to the UN Charter, and or in my language, it doesn't really give way to the UN Charter. It doesn't actually govern the spectrum of activities, or the realm of activities that the UN Charter governs.
So I
So
guess
it doesn't. Yeah.
yes. No, go
There
ahead.
you go.
Sorry. Go ahead.
The neutrality law essentially doesn't really affect any right of the states to use a collective self-defense, and it does not harm the rights of states in that regard.
So I guess I want a clarification on the customary law status of neutrality law. And I agree with you that if you turn to the Max Planck's Encyclopedia of Public International Law, which you cite quite a bit in your piece, Michael Booth there basically agrees with you that it is customary international law, which actually surprised me. But when you cite the practice, more current practice, you cite things that I think are along the lines of course, you can opt to be a neutral, but you are not required to be either a neutral or a belligerent, or restricted to the world of collective countermeasures, which, as you describe it, are quite vague on how far you go down the line and how different they might be from conferring a military advantage. So I guess I want to press you about the current customary international law status of your view of neutrality law, which is not optional, that yes, you always have that option, and states have it as an option and refer to it in their military manuals, and you've got the UK and other instances where you can point to this, and Swiss have asserted neutrality for quite some time. So I totally agree, you can always opt in, but where's the customary practice that supports what the Max Planck Encyclopedia declares affirmatively is continuing valid Hague Convention, continuing valid customary international law?
My view is, firstly, historically, it is a mandatory provision. It's a mandatory position that states must adopt a neutral position, and that's codified in the Hague Convention. And obviously, the subsequent question is whether there's, sufficient widespread state practice that allows us to conclude that historical position has been overturned. And I completely agree that states have been extremely ambiguous, especially in recent years, about whether what the positions are with respect to assisting other states, and whether neutrality is still a mandatory thing. Although suffices it to say that obviously there are still permanently neutral states like Switzerland and formerly Austria. But my view is there's no because state practice, especially in recent 20 years, is so inconclusive that states offer no justification with respect to using force or providing assistance or even using force towards a belligerent state in armed conflict. We simply don't know what they think the justification is, but on an analysis that neutrality law historically still exists, there's a treaty there, there's as it reflects customary law at that time, that it's a mandatory position. There is nothing to suggest that that has been overturned, and there's no sufficient state practice to suggest that that has been overturned. And I think that's how I put it.
Okay, so a good chunk of your article is a rather rich discussion trying to bring up to date the 1907 Hague Conventions to address the current forms of military intelligence, training, logistical support, diplomatic, financial, banking, cyber, and technical assistance. The broad message that I get from your article is that anything that contributes a military advantage to one side winning violates the rules of neutrality. And at first, I want to clarify that that's the position. And if so, does that mean that trade sanctions, whether it's multilateral through a regional organization, whether or not authorized by the UN, is that reached by neutrality law? Just simply denying or giving trade, is that a violation of neutrality law?
With respect to the first position, yes, in a qualified sense, that what I did in the article was looking at the words of the Hague Convention and looking at what they're essentially governing, and an important phrase in Article 6 of Convention 13 is that it prohibits states from supplying warships, ammunition, or war materials. And I say yes in a qualified sense because whether a material such as cyber threat intelligence, for example, constitutes a war material, a large part of that depends on whether it confers a military advantage to one side of the conflict, and whether it's a material in that sense. But I would say no to the second question. I don't think sanctions and economic sanctions per se would constitute war material, because it doesn't. I don't think it satisfies the ordinary meaning of being material that a state has provided to another state. I think. Yeah, I don't think sanctions.
So no, it's a subtle
plain meaning.
it's a subtle distinction, but I wanted to raise that because when I start my international law course, I start with an old case of La Paquette Havana in the Supreme Court, and the exception to not seizing fishing vessels in prize is if they're large enough to contribute financially through commercial shipping to Spain's ability to win the war, was considered basically not covered by that humanitarian exception. So even back in 1900, you had authority for the proposition that you breach neutrality and you're no longer a neutral fishing vessel if you contribute financially to that side of the war. So you're saying that's no longer the case?
I think it doesn't per se, but if it does, if it confers a evidently strong military advantage to one side by virtue of that economic sanction. I didn't consider sanctions as possibly being within the meaning of, for example, war materials, or meaning of being impartial with respect to a war, because a lot of the sanctions some of the sanctions might not actually, it might be a symbolic nature, that it might not actually affect the trajectory of the war in any material sense. And in that case, I think it prima facie does not really constitute a violation of neutrality. But I do agree that in cases where it constitutes it confers a material advantage to one side of the conflict, it could constitute a violation of neutrality or impartiality obligations therein.
Well, one of the things that I admire about your piece is that you say that even private parties can involve a state in this. So a private party supplying satellite assistance to Ukraine, for instance. And I would assume that that means that North Korea sending troops to the front in Ukraine on behalf of Russia, or China doing some of the things might be in violation of neutrality law or siding with one side. But I'm curious, from your perspective, are those cases, North Korea, China, instances in which those states are not just not neutral, but are they also co-aggressors?
I think the answer to this question I might need to borrow your brain about and your expertise about the UN Charter and the use of force threshold, which is something I didn't engage in the article. What I would say though is, I think so. I think providing troops to a state in the name of the state is a huge thing. It is a provision of not just static weapons and firearms and so on. It's literally fighting the war. So I think it does rise to the level of the use of force, requires it to be a co-participant in a conflict, but I haven't engaged in an expert analysis on this.
So let's turn to
issue.
folks in the
It's
audience.
interesting.
We promised at least 10 minutes of questions, and I hope you've now gotten enough. They don't have the advantage of either an article or an executive summary, so I hope you've gotten enough gist to ask questions. So please, anyone. I think the JILP will offer you extra credit if you ask a question. Yes, please, Tamara. Do we need a mic for you?
Yeah, we're gonna pass the mic. Who is?
Thanks so much. Hi, Sherry. This is Tamar Megiddo. Thanks so much. I look forward to reading the article. I wanted to press you on two issues or two questions. One is, if I understand you correctly from this conversation, what you're suggesting is that states are allowed to join the war in the aid of one of the parties, but they're not allowed to support that party in another way, right? To provide financial aid or trade or weapons, et cetera, because that would be in violation of the laws of neutrality. And so my first question is, would that not lead to more war and more violence? Because we're pushing states to actually engage in war, to aid these smaller countries that we are concerned with. The second question is about really the issue of trade. So if I understand correctly, and you're the expert, so correct me, neutrality law was to a large extent about preserving the pre-belligerency status quo in terms of trade with both belligerents. And my question is, and that echoes one of Jose's questions in your conversation, is can we really say that this is still good law in the world where we have, at least since the 1930s, global or regional or alliance-based sanctions against one of the belligerents when that belligerent is considered to be an aggressor? So I sort of have a doubt about the extent to which this is still good law. Thank you.
Those are great questions. In response to the first question, not necessarily. What I was asserting is, what I was saying is a sphere of governance issue. Neutrality law does not encourage states to go to war. What neutrality law does is that when states do not decide to go to war, what can they not do? And the thing is, they cannot provide weapons or funding to one side of the conflict. But whether or not states can join the war, a war, in aid of a belligerent state depends on Article 2.4 of the UN Charter and Article 51, whether Article 51 self-defense applies in that situation. And those are things that neutrality law does not govern. So in that sense, it governs a completely different thing, or relatedly different thing. And what it doesn't do is encouraging states to go to war, and that other thing is governed by the UN Charter. As to the second question about essentially whether neutrality law hampers pre-existing trade or commerce between states, my answer is no. Well, my answer is yes in a certain way, because states, in times of wars, neutral states could not, for example, authorize more exports to weapons export to a certain country. But it was clear in there was an article in the Hague Convention 13, Article 7, I think, that says that states are not required to prevent private actors from doing their own business even during wartime. So private actors in this global economy can still do what they were doing prior to the war, during the war. Neutrality law only applies to states, and states might not additionally do more business with a belligerent state during wartime, but it's only at that moment of the duration of an armed conflict that neutrality law comes in to tell states what they can or cannot do, but it doesn't prohibit private actors from seizing any of their commercial relationships.
I guess I could want to press you, in the world of today, extraterritorial application of your law to your private actors in commercial is quite common. That is, it's because of licensing arrangements that permits certain very powerful private actors in the United States to enable to have commercial satellites and so forth that could come to the aid of Ukraine. So I'm having trouble distinguishing public and private action when it comes to issues very close to the ones that you describe. In other words, the intelligence and everything else could come from very private companies that need the authority of the United States, because these usually implicate national security matters, for instance. So I think you would agree that if you need a U.S. license in order to do some of the things as a private actor, or if it is because of state action that you have those capabilities because you're subsidized, or now in these days, you're co-owned by Trump, then wouldn't you agree that that's covered by neutrality law?
I think what I do is I looked at the words of the relevant obligation, and the words are that states must not supply indirectly or directly raw materials and so on to the belligerent state, rather. And it is a complicated, like, factual analysis point where whether private actors co-owned by states, or whether they are merely obtaining a license to operate in Ukraine, for example. And I think that is actually a gray area that neutrality law doesn't govern, or that this obligation doesn't apply, because the use of the words is, states must not supply directly or indirectly, kind of implies that the state must still do a little bit of thing to and involve in that process, albeit it can be somewhat passively. So I think simply automatically providing a license to operate in Ukraine for benign, neutral intelligence, cyber intelligence activities that doesn't really have anything to do with the Ukrainian military or the Russian military doesn't necessarily fall under that obligation. And I think the state should do something more. So, for example, the US government actively pronounces a partnership with a private actor that says the purpose of this partnership is to combat Russian aggression, I think that would fall under the neutral obligations. But yeah, it's a case by case factual analysis, I think.
Any questions as we're running through? There's one here. You raised your hand, right? Oh, you have your.
Hi, thank you to both of you. This has been a fascinating discussion. I wanted to ask about how you see neutrality law as fitting into the concept of collective crime. So specifically citing to Special Rapporteur Albanese's report last year on the ongoing genocide in Gaza as a collective crime. Her central argument was that it has been sustained by the complicity of influential third states that have enabled longstanding systemic violations of international law by Israel. So I was curious if you could speak to, do you think that neutrality law provides an alternative legal framework for the idea of collective crime in the case of genocide in Gaza, for example, or in other examples that you've provided? Do you see that kind of as complementary? Do you see those two legal frameworks for accountability as coexisting? Thank you.
Yeah, great question. I think they're complementary. I think it's complementary in a sense that the effect is the same that neutrality law provides, that you can't assist states in conflict. The other sort of collective crime provisions, including complicity in committing a war crime and complicity in genocide, facilitating genocide, and so on. The effect of that is also don't assist the state in conflict, like committing genocide. The sort of theoretical difference is that neutrality law is funnily also quite neutral. It doesn't itself provides which state you can't provide assistance to. It provides that you can't provide assistance to any state. But then obviously there's a catch-all that I mentioned, that there's the collective countermeasures that you might use to provide assistance to states under attack, under grave attacks such as genocide. So yeah, I think they work concurrently. Neutrality works concurrently with other frameworks of international law, including IHL violations, Genocide Convention, and so on. And I think it provides a good alternative pathway to asserting, for example, in circumstances where there might not have been grave violations of use cogens, or that might not have been evidence that states are complicit in the genocide, because or complicit in committing a war crime, and that's also quite difficult to prove. And because those collective crime obligations are quite difficult to prove, I think neutrality law offers a good alternative pathway to regulate state accountability in that regard.
So unless I see another question, I just want to give you an opportunity to say, what do you think ought to be the next step to the extent policymakers take your views seriously? It sounds to me like you would like clarification, or I think the world would, on what can you do under countermeasures, since you seem to favor that route. But it also sounds to me like the folks who drafted things like the Tallinn Manual on what states can do in response to cyber attacks need to re-educate themselves on neutrality law. But I leave it to you as to what is the next set of prescriptions that follow from your article.
So the Tallinn Manual does have a chapter on neutrality, although it's 10 pages and doesn't really say a lot of things about neutrality, although it says that neutrality does apply to cyber infrastructures. So this is a good progress, that new expert manuals, cyber military law reports are citing neutrality and trying to incorporate neutrality into these new forms of weapons in contemporary warfare. I think the next step would be a slightly more discussion about how to maybe draft a whether it's export report or a state consented report or in General Assembly or so, or expert report or so on, about the clarifications about updating the Hague Convention, and how the Hague Convention can, because the words in the Hague Conventions are quite vague, and I would like clarification as to how these would apply to each and every form of assistance, for example, and obviously, as you said, collective countermeasures. How does it apply? Whether it applies, but this is also the mystery of international law, is that it depends on state actions and evidence of state practice and customary law in that regard. And I fear that the less states are asserting neutrality or asserting breaches of neutrality, well, the only state kind of in the past 5 years who've asserted neutrality is Russia against Ukraine.
Lovely.
But yeah, so
that's very helpful. And
forward.
also, I think you suggest that the International Law Commission has a full agenda that you could bring to the table if they are in charge of revising the Hague Conventions, and especially the 1907 ones that you're referring to. But thank you so much for participating at a terrible time in terms of your actual location. So we really appreciate it that you're doing this on Zoom, which is not the ideal format. But thank you, and I look forward, as everybody here, to reading the final text of your article. Take care.
Thank you so much. I really enjoyed it.